or the material date or the fateful night part of his plan to commit the murder. The statement to Owen. In other countries, you can commit an offense and walk out with it. You can't walk out with it, but in Kenya, you can commit an offense and walk out with it. Because, and even impersonate, no one would really follow you. We don't have that. What does it speak to? Number 5. The evidence of Jennings. He was left and he says when the accused person came back, he told him that he had quarreled with a girlfriend from South Sudan. But even more so, that when he came back, he looked agitated, he was not in the mood, and seems to be in a hurry, and he didn't want to advance anymore the discussion they had. Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. I picked this from the post-mortem report. That the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now this brings me to what played before this court heavily as I have this case. On very many occasions and during cross-examination, the counsel for the first accused person kept on putting to the witnesses, have you ever slaughtered a goat? And the witnesses would say, yes. And what impression was created in the court's mind? That the manner in which the deceased was killed was akin to slaughtering a goat. And so the argument of the first defendants, accused, was that if I really killed her the way she was killed, the way a goat is killed, how come the blood didn't go on my cloth? I have had the benefit of looking at the photographs by the scene of crime. And it's very clear that the deceased and the person who killed the deceased did not intend to give her room even for 1 minute to survive. Now, I've said Dr. Nzioka said that the airwaves and the jugular veins were cut through and through. So I checked on the functionalities of these organs that were targeted. And this is what I found. The carotid arteries are major blood vessels that provide one's brain, supply blood to the brain. I established that a person has 2 of them on either side of the neck. I discovered that they're actually a cause of at least 1/3 of all strokes. And that a stroke occurs when something blocks blood flow to your brain and causes brain injury. Therefore, they are a very important part of one's circulatory system that sends oxygen-rich blood to organs and tissue in the head and in the neck, including the brain. And then checked on the veins that were targeted. And I discovered from my search and reading, they are major blood vessels that stretch from the upper head, from the head to the upper chest. There are 3 pairs, total of 6. And the reading, my further reading shows that when the arteries and the veins that were injured on the deceased body are severed or they're cut, then no blood is supplied and the victim cannot even survive for a minute. It's my considered observation, opinion, and finding. And it's noteworthy that this deceased person had injury on the neck only, occasioned by a sharp object. It is my considered opinion the target of the neck clearly indicates that the perpetrator was fully aware, intended to, and did actually target for purposes of instant death of the deceased person. Does this connotes malice aforethought? I did, and I've made an observation. When you look at those photographs, you don't want to look at them again. The slitting of the neck was not just on the front, right up to the back. And I made an observation. It's no wonder, and then in our hearing we heard of slaughtering of a cow or a goat. The evidence of Chief Inspector Otieno is that the person who committed this offense was not an amateur. He's not a person who has no training in military, or because the way it was done with such precision that you can't go wrong. And so I asked myself, does the first and or the second accused person have any training in military or military training? And that took me to the following. According to the evidence of the prosecution witnesses, and I'll start with the evidence of Jennings, when he met the first accused person, they were on a VIP protection exercise, and it said that that is when the US president was in Kenya. And he says they then became friends, and they were actually discussing how to form a security company. The house help says in her evidence, she asked the second accused person what the first accused person was doing, and the second accused person told her he's a soldier in Dubai. Owen says the deceased introduced the first accused person as a security in Interpol and Office of the President. In fact, according to Owen, they even spoke how he was going to help this witness secure a firearm. Jennings says that the first accused person told him that he had been working with a security company in Dubai. And he also told him that he was offering VIP protection to state officials in Kenya while on leave. According to Kasaini, he gave the first accused person a gun because he knew the first accused person was working as a private military officer who covered several politicians under an undercover, so to speak. That he worked as a private military contractor in Dubai and was guarding the former Senator Joyce Ray. It is the finding of this court that for one to engage in VIP training, they definitely must go through training. And that training would not be too far away from the training offered to a military officer. And if the first accused person went through this and he murdered the deceased, then he had the know-how. The conduct of the first accused person and his conversation with the deceased brother. When the deceased brother told him, look, can you help me get press? Can you ask your fiancé who is in the media industry? It is in evidence. The first accused person told me, forget about the media, they won't help you. I don't know, you are here. I have a private company, let me do it for you. What does that statement speak to? A further issue I picked up, he says, look, the person whom the deceased allowed into her house was Dominic Becerra Harun. And she must have known somebody by that name, and that's not me. And my simple finding on this is this. If this first accused person is introducing himself, I work at State House, I protect the President of the States of America, I am in a security company, I am an undercover, is it far-fetched to imagine that even when he told the guards at Ramuria Gardens, I am Harun, the deceased would not have contradicted that because the deceased also introduced him as somebody who works at State House. So we all know that, hopefully, the court is making a right observation, I think I am, that people who work as undercovers will not quickly volunteer their true identity. And that could inform why, even when he said I'm Harun, and the deceased knowing whom he has said he is, would quickly say, let Harun come in. And then in the house gives him his true identity to the other persons in the house as well. So I didn't find it difficult in coming to a conclusion that it is explainable. Is this case based purely on circumstantial evidence? And has the prosecution met the threshold of circumstantial evidence? You'll allow me to just pick extracts from the cases. I'm coming to the tail end of my judgment. Cases that speak to circumstantial evidence. Some very critical areas I think will guide my findings. Mohammed and another versus Republic 2019 speaks to circumstantial evidence is often the best evidence. It is evidence of surrounding circumstances which by intensified examination is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it's circumstantial. Republic versus Juma Kaviha Kalama. Circumstantial evidence is particularly powerful when it proves a variety of different facts, all of which point to the same conclusion. I have given emphasis, my own emphasis, on the following. It works by cumulatively in geometrical progression against other possibilities that has been likened to a rope composed of several cords. One strand of a cord might be insufficient to sustain the weight, but 3 strands put together may be quite of sufficient strength. There may be a combination of circumstances, no one of which would raise a reasonable suspicion, but the 3 taken together may create a strong conclusion of guilt with as much certainty as human affairs can require or admit. Emphasis added. Having considered the evidence in this matter, it is the finding of this court, yes. The case is based on circumstantial evidence, but the prosecution has adduced adequate evidence and has met the threshold. And to sum up, did the first accused person kill the deceased? It is the finding of this court. I'll play back for purposes of my finding. The first accused person stole the ID of Dominic Becerra 2 days prior to the commission of the offense, armed himself with a gun, carried a counsel, put it over his cloth, went to Amoria Gardens, disguised his identity, gained access to the apartment of the deceased, murdered the deceased, left the deceased house, changed his clothes, and eventually went home and burnt the cloth which he wore during the commission of the offense. It is the finding of this court that all this evidence taken culminatively leads to a strong conclusion that the first accused person murdered the deceased. And therefore, it is the finding of this court that the prosecution has proved beyond reasonable doubt all the ingredients of the offense of murder. The death occurred, the cause of that death, the person who, and in this case the first accused, I'm still on the first accused person, committed that offense, it was not a case of homicide, excusable homicide, it was unlawful. And therefore I find the first accused person guilty as charged herein of the offense of murder, that on the night of 19th of September 2018, at an unknown time at Ramoria Gardens apartment, he thoroughly off Dennis Pitt, with others known before this court, he murdered Monica Nyawira Kimani. The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police. One saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day, only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives